truth, liberty, and justice for all. Thank you. So just so you do know, we invited all the judges. There's a bunch of them. And those appearing, all of them that were appearing on the ballot. So the guys that are up there, the people that are up there, they do not have opponents. They're running unopposed. And they felt that it was just best to allow the 5 people that are here this evening to be able to really introduce themselves to you and to have you get to know them so you'll have that choice. So, one thing that I found about judges that I thought was interesting as far as the election and numbers and all that stuff goes, approximately 25% of the ballots that are turned in just leave the judges' positions blank. And they do that because they don't know who the judges are. So that's really the purpose that we're having the meeting here this evening. Now I guess when you really think about that, that's a heck of a lot better to leave the selection blank than to check something and you don't know the heck about anybody, So I really applaud those voters for saying, hey, I don't know, so I'm not going to vote. But the reason we're here this evening is so that you can make a determination as to who to vote for. So these are our candidates that we have attending this evening, and that's not the slide I want. What happened to my slide? Well, my slide went away because I worked on it a little bit. So before we start, I just want to let you know a little bit about the court system in the county. Because you sort of wonder, we have district court judges, we have superior court judges, we have this, we have that, all that kind of thing. So district courts are the courts that hear traffic infractions, criminal traffic citations, misdemeanors, gross misdemeanors, civil cases in the amount, if that amount is under $100,000, that kind, or $75,000, that kind of thing, small claims suits, those things. The superior courts, they can consider all civil matters and criminal matters. So they could take something that you'd think, boy, that should be in the district court, but not necessarily. And superior courts also have the exclusive jurisdiction over civil matters in which the amount of controversy exceeds $75,000. Felony cases, estate and probate matters, family law cases, and juvenile proceedings. They act as a court of appeals. So if the district court renders a judgment and the people appeal, then it goes over to the superior court, that kind of thing. Both of these positions are elected to serve a 4-year term. So how we're going to start this is by having the candidates take about 3 to 5 minutes, each tell us about themselves and perhaps the challenges that they see in our court system. What is our court system facing? And so we're doing this alphabetically, and so we'll start with Randy Brandt. My last name's with a W, so it's really great. I get to see what everybody else is doing. You're up there. And so thank you. It might work. That would be nice.
Can you hear me all right?
You're going to have to get close to it.
Have to get close to it.
Yeah.
All right.
Is it on, Seth?
It should be on.
Well, I know it should be.
Oh, sure.
Sure. There we go. Now
Can you hear me now?
Yes.
I thank you. This is an important opportunity for the 3 of us that are running for District Court Position 1. And right out of the chutes, I want to say that I'm the one with the judicial experience from the bench. I've got 21 years of hearing cases. Background is I'm a lifelong resident of Spokane. Graduated from Lewis and Clark High School, yay Tigers, and Gonzaga University. I'm a double dog, Gonzaga University undergrad for my BA and my law school.
Go Zags!
Go Zags! And before that, I had two brokerages. I was a real estate agent for many years, escrow officer, life insurance agent holder. So I've gotten a lot of experience on the different professions. And that all came back to pass with being a judge. And I had 60 agents that I was supervising, over 60 agents, so I had a lot of experience in management and how to work with people. I have a lot of interaction, extensive interaction with dealing with people in our community. I attended the Gonzaga University ROTC program, the Reserve Officer Training Corps, and enjoyed it, loved it. The food at Army forts and Air Force bases is better than my dear mother cooked. So my father said that my mother lost the recipe for ice and she burned cornflakes. So powdered eggs are great. Now there's going to be a test afterwards of these dates. I became an attorney nearly 30 years ago, and in 1988. And 5 years later, I had to wait 5 years to start serving as a judge pro tem. So in 1993 is when I started gaining my judicial experience. So from 93 to 2003, that's 10 years, I was on call as an attorney to hear cases. I heard let there be light. Oh, yeah.
Light helps.
And a lot of experience because of my civil business experience. I was asked to do a lot of the small claims dockets. You know, landlord, tenant, not in eviction sense, but on the recovery of properties and such. So I served 10 years as a judge pro tem. Then I was appointed by the judges as a court commissioner. In 2003, for nearly 7 years, a little over 6 years, I guess, as a commissioner. And that's appointed to serve as a judicial officer and at the behest of the judges. And then all 5 of us commissioners lost our job because there was a reduction in force. So we left there. I then moved to the state, and I heard appeals on unemployment cases as an administrative law judge. I was then appointed to the district court judge in 2011, and I served there until 2014. As a judge, I rode the circuit. I would go to Stevens County, Ponderosa County, Ferry County, Whitman County, Asotin County, and I would hear cases in those counties because I was experienced to the point that I could be trusted, in essence, to go down and hear cases in Clarkston or Colfax for Whitman County and things like that. And it really requires a broad base of experience to do so. As presiding judge, I held a position in the Spokane Regional Law and Justice Council, serving in that and working to improve therapeutic courts, which I'm a strong endorser of, and do what we can to reduce the use of jail. And that's a very complicated formula. But I've been striving since 93 to try to reduce jail, therefore cost, therefore taxpayer savings. I've served every docket, and I've taught new judges on every phase of the judicial process. I've written them down here. We've got the domestic violence. I was the presiding judge for the mental health docket, the therapeutic court, anti-harassment, no contact orders, traffic infractions, misdemeanors, gross misdemeanors, felony arraignments at times, and I've been a graduate of the Washington State Judicial College 2004, 2012, 2014, and the National Judicial College in 2009. Presiding over the mental health docket is a passion. I love working on that docket. I've received extensive and advanced training in the military issues, the issues involving military personnel, PTSD, post-traumatic stress disorder, military sexual assault, and traumatic brain injury. And that's another labyrinth, and so if we can help our returning service members, it's been a pleasure and an honor. I was given a grant. I got 3 grants at different times to attend domestic violence training at the federal training level, which was very helpful. My peer judges elected me as their acting presiding from 2011 to 2014. I was then elected as the presiding judge in 14. I developed a program, or a system I'll call it, of digitizing paper documents, putting this into a computer. And then we added another monitor, another computer, to the front of the arraignment desk. And then we also remodeled that to reduce danger to the participants by putting benches in there instead of chairs, which are a weapon. So I could have someone come in, and this leads to saving taxpayer dollars and expediting everyone's resolution of a case. Over 80% of the cases that came before me on an arraignment docket were resolved that day. And part of that had to do with, I could take a double load. I could take 100 cases where others may take 40, 50, 60. I always ask for 100. And so when someone came up, I could talk to them about their charge. I'd advise them of their rights. I'd ask if they've had an opportunity to meet with an attorney. If not, I'll appoint one for you free of charge. And so then they would have a public defense attorney there, they'd have a prosecutor there, and they could 80% of the time resolve under the early case resolution docket. Huge benefit to them and the county taxpayers. And then there's an agency called the Administrator of the Courts, AOC, and they issue computers to all judges throughout the state that are on the Superior or the District Court, and I believe maybe the municipal, I'm not sure on that one. Judge Zamlin says yes. And so they were going to scrap them, and I said, well, wait a minute, we can use those. So let me give you a quick history on arrest warrants. So if a law enforcement makes a traffic stop and they have someone in their car that they may need a search warrant to get a blood test for possible DUI charges, or if there is something that's happened in a house, you know, tragically maybe someone has been injured in the house or something like that, they need to get a search warrant. Now, what that used to require was the law enforcement coming to our house at 2, 3 in the morning. So when I found out we were going to get rid of these computers, I said, well, we have a use for them. Let's put them in the homes of the judges. Let's develop a software so that the officer from their vehicle can send in a request. Call us on the phone. I've got a search warrant in the queue. Get up at 3 in the morning, look at the search warrant. If it's appropriate, we were able to electronically attach our signature, send it back to the officer, and that loop took about 7 minutes instead of an hour or 2, because if the officer's coming from Deer Park, Airway Heights, Liberty Lake, we're burning a lot of daylight, and I probably am too. So it saves taxpayer dollars, and it's a big safety issue for law enforcement, so that they don't have to keep someone in the back of their car in front of my home at night on occasions. Judge Zamlin knows how that worked. I've served for nearly 30 years in the legal profession, and I've served 21 years as a judicial officer, including presiding judge. I've served our community from the time I was in business, ranging from the board of directors of the Campfire Boys and Girls, the Exchange Club, Spokane Central Lions Club, I'm currently a member, Spokane River Association, and I'm now the president of the Spokane Regional Law Enforcement Museum. It's a great organization that gathers artifacts from first responders, and we save them. I've been an honorary member, and I'm closing up, thank you. I'm an honorary member, honorary commander of the United States Air Force out of Fairchild Air Force Base. Have been for, I think, 16 or maybe 17 years now. And I also serve our community as a judge on the DUI mock trials. So we're trying to curb alcohol consumption. So in closing, let me ask you a question to ponder. If you're going in for heart surgery, do you want someone that's been in the surgical suite for 21 years and has done 75,000 heart surgeries? Or do you want people who are nice guys, but they've never done a surgery like that? They may have presented the surgical process, but they didn't have a scalpel in their hands. You've got to be on this side of the bench to gain that experience. So thank you very much.
Thank you. All right, thank you very much. Next I'm doing district court first. I know, alphabetical, district court, alphabetical, Superior Court. So next will be Patrick Johnson, and he is a candidate again for the district court, and welcome. He doesn't have notes. That's cool.
Good evening, folks. Really appreciate you guys taking the time and coming out here and learning about the candidates for an important job. I know it's hard. I had a chance to talk to a lot of people sitting out there who say, you know what, we don't know who to vote for because there's no R or D associated with the name. People usually, unless they're on a criminal docket charged with a crime or a victim, don't really have a lot of background with a judge. So I want to talk a little bit about what we're running for and why it's important. All three of us are running for a job that's coming open. Judge Vance Peterson has the job right now, and he's a good judge. He's been a judge over 20 years, been on the bench a long time. And what's special about Judge Peterson is that he has a military background, actual military service. He was a lieutenant colonel when he retired, and this is a kind of guy who's a snake eater. You know what I'm talking about? A special forces guy who went out there. I'll tell you a little story about him just quickly. He did a court hearing one time. He was allowed to testify by phone, and he's doing his testimony. And all the time he's doing his testimony, he's talking to this hearing panel. He goes through with about half an hour, hangs up the phone. What they never knew is that he was doing a ruck march the entire time he was testifying. He had a rucksack on his back, 50 pounds of gear, and was still doing this conversation. That's the kind of guy that we are all running to replace. In terms of district court, he started Veterans Court. He started that in 2009, and it's a great program. This is a program that teams up our veterans who are charged with crimes, gives them a mentor, helps them through the system, and gets them progress. They have kind of benchmarks, level 1, 2, 3, 4, and they work their way through. At the end of this program, for these folks that get through it, 15% recidivism rate, meaning they break the law again, 15%. What do you think it is for the general population, folks who go through district court? 70, you would think, maybe 70, maybe 100%. No, it's 43%, but still, that is a huge reduction. So that's the kind of program I want to take over. Right now on the district court bench, there are 0 military veterans except for Judge Peterson, and he's leaving. I am the only candidate with actual military service. I have served 25 years in our military, and I'm a major right now in the U.S. Army Reserves. I didn't start out a major. I worked my way up. I enlisted back in '88. I enlisted to jump out of airplanes. Fort Bragg, North Carolina, airborne. And I did my probably 30 jumps when I was enlisted. Did my time in the Army active duty. I got out, went to college, used the GI Bill, and after getting a law degree at Gonzaga, graduating with honors in '98, I wanted to go back into the military. I wanted to serve again. I also wanted to have a day job, so I did the reserve route. I signed up as a reservist, as an officer, and for the last 17 years of being an officer, my job has been defending soldiers. Our motto is defending those who defend America. So when our soldiers get in trouble, they need a lawyer. They need a strong voice to protect their rights. I've been that strong voice. So I want to talk about the qualifications I have that make me the best candidate. You've heard about my service in the military. I want to talk about balance. You've heard how I defended soldiers. I not only have defended actual clients, for the last 20 years I've been a prosecutor. And I'm proud of that duty. I've moved my way up, prosecuting misdemeanors, gross misdemeanors. I moved my way all the way up to major crimes, prosecuting murder, rape, child molest. I was the elder crimes prosecutor in Spokane for 5 years, dealing with financial exploitation of our elderly, as well as physical abuse. I did that for 5 years, and I was a local, state, and even national presenter on the topics of elder abuse. Proud of that service. In addition to the kind of balance I'm talking about with being a long-term prosecutor and a long-time military defense attorney, I have the actual experience of being in a courtroom. I have completed over 150 trials. More than 100 of those are felony trials. Important stuff, important work. And why is it important to have trial experience? As a judge, you gotta know how to rule. And how do you know how to rule unless you've been on both sides and know both arguments and which is persuasive? That's what I've got going for me. I also want to tell you, I have support. I have the support of the judge we're all running to replace. Judge Peterson has seen fit to endorse me. He believes I am the best candidate to replace him, and I am proud of his support and endorsement. And you know what? He's not alone. I have by far the longest list of endorsers of any candidate as far as judges. And what does that tell you? People who know how to do the job, people who are already doing the job, and retired judges support me as the best qualified candidate to take this job. I have the training to do this job and the background and experience and support, and I hope that, as I understand it, ballots are coming out. I heard half of them got mailed yesterday, the other half today. Raise your hand if you guys have received a ballot. Okay, yeah, so we got a lot of folks already who have their ballots. Open that up, take a look at your selections. I invite you to grab one of my flyers, and I hope for your vote as the ballots are coming right now. The deadline is August 7th, so please act on them right away. Thank you, folks.
And next we have Lyndon Smithson, and we spelled his name correctly one time and incorrectly the other. How about that? So I apologize for that, and thank you. Come on up.
Thank you. Thanks, Esther. Good evening, everybody. How are you? Good to meet everybody. It's nice working the room and talking to everybody before we got started here. And as she stated, yes, my name was misspelled earlier, Lyndon, but some people that were around for that presidency, it's probably okay because it's a little bit easier for you to remember that than Lynden. In any event, I'm glad to be here. Thank you for all the agencies or the organizations that had us here. This is a great format. This is a great forum to have us out, and we greatly appreciate it. I also need to thank my wife right off the bat. She's done a great job in this campaign, is the engine behind, thank you. She's the engine behind everything that you see, so I appreciate that. So a little bit about myself. I have been in the Washington area since about 1980 or so. I grew up in San Diego. I was born there. Went to school in Tacoma, Washington, graduated from Bellarmine Prep in 1990. I came over here for law school in 1995 at GU, graduated in 98, and I've been a lawyer since that time. Started out at John Cooney & Associates office doing criminal defense, representing people that have been charged with misdemeanors, DUIs, thefts, those types of things. After that, I transferred on to a civil litigation office. We did a small amount of criminal work. I kind of carried some over, but mostly we did civil litigation. We handled employment discrimination cases. If somebody was sexually harassed, we would represent them. We did insurance defense, whereas basically if you were in an accident and sued, your insurance company is required to hire a lawyer, handled those cases. I did some immigration law as well. Shortly after, well, a few years after that, one of the people that I had worked for before, Howard Delaney, was a city prosecutor. He had an opening in his unit, and he asked that I would come over and interview. I did, and I worked at the city prosecutor's office for the last 15 years. Currently, I'm head of our domestic violence unit there. It's one of our specialty courts that we deal with in municipal court. Municipal court is a lot like district court in that we have a few of those therapeutic courts, community court, mental health court, a domestic violence court, and we also participate in veterans court. So I've handled those cases as well. But some of the things that kind of drive me and make me who I am is, in college I played soccer. I played at a collegiate level, and at that time I had kind of a difficult time keeping up with some of the players because they were smarter. They were more intellectually gifted at soccer, and I wondered how that was. And it came down to they had better training when they were younger. So after that, and after I had gone through law school, I decided I was going to help coach kids and youth soccer and try and make them better than I was at that age. And so I've done that as well for the last 15 years. I've gone through the United States Soccer Federation. I've earned 3 different degrees from them, a D license, a C license, and a B license. Each one of those is a week-long program. It's pass-fail, so if you don't qualify, you don't make it. And as I stated, that's the reason that I started doing that, is I wanted kids to be better than I was. And also, as I found, is that when I'm involved in that, we also have kids, even out here in the Valley, that are involved in situations that probably they shouldn't be. And I've had kids tell me that, Coach, I need to come out to practice twice a week, and if you could come out another night, it'd be great, because the more I'm at home, the more I'm going to get in trouble. So I've had an impact with those kids and the youth of our community. And my run for judge is kind of an extension of that commitment to the youth of Spokane and to Spokane as a city prosecutor. That's why I'm running for judge. I'm also running for judge because I'm a community leader. I'm going to invite you to go to my website, lyndonforjudge.com, L-Y-N-D-E-N, forjudge.com. It's on our palm slip, on our Slim Jim, so grab one before you leave. In that, you will see that I've been quoted in the paper. As recently as 2 weeks ago, I was called for an interview on domestic violence issues. I was asked to be on a panel for domestic violence issues back in April of this year. I have worked with other judges in our community. I've worked with other agencies in our community working on domestic violence issues, and that's another reason that I'm running for judge, because I am a community leader. And one other thing that drives me, and one thing that has always been instilled in me, is that notion of what do you do when nobody's watching? What do you do when nobody's looking at you? When your boss hands you a project, do you work on it hard because you know he's looking at you, and then at the end of the day you're like, well, done with that, he's gone, I'm going to go have a beer or whatever? Or do you work hard on that project because that's what your job is? Do you work hard on that project when nobody's watching, when nobody's going to hold you to task, and just out of your own personal drive, you work your hardest on that project? And that's another thing that I'm about. So I'd appreciate your vote in this election. A little bit about my endorsements. I don't generally talk about my endorsements in public, but I think it's important to note that I am endorsed by the highest seated Republican in Washington State, Kim Wyman, our Secretary of State. I am endorsed by our former Secretary of State, Ralph Monroe. I have a number of judges who have endorsed me. I have Regina Malvo, the CEO of the YWCA, for my work with victims of domestic violence. I have her endorsement. I have the National Organization of Women President for Spokane Chapter. I have her endorsement because of my work with victims of domestic violence. And more importantly, or something that I'm extremely proud of, is that I have a lot of businesses who have endorsed me. You'll see my signs in front of different restaurants, different coffee stands, different places around Spokane Valley and the city of Spokane. I'm extremely proud of those. These are people, hardworking people, that have jobs, that run a business, and they saw fit to put my sign in front of their business. So thank you, everybody, for your time. I greatly appreciate it. Thank you.
So now we'll move on to the Superior Court. And we have two candidates this evening. And we have Dennis Cronin, and so here he is.
Well, good evening to all of you. I think I met some of you at the Lincoln dinner not too long ago, which was a fabulous dinner, although it went a little too late for me because I generally get up about 4:30. I am Dennis Cronin. I'm running for position 10 in the Spokane County Superior Court. I'm the oldest one here, apparently, at 57 years old. I've been practicing for 33 and a half years, and primarily in the Superior Court. In the Superior Courts across eastern Washington and a few in western Washington, as well as the federal court. I was a judicial officer in the Spokane County Superior Court from 2005 to about 2015 as a commissioner pro tem. And I've been on a variety of committees. I was told I had about 3 to 5 minutes to share with you this history, and I really don't think I could do that after 33 years. So I encourage you to go to my website, DennisCroninForJudge.com. Take a look at that, please. You'll see the resume, which is the summary, which is 15 pages, small type. And you'll see all the people who endorse me and the communities that I've been involved in. As you see from the sign, presently I am the chair of the City of Spokane Ethics Commission. I previously was the chair of the Human Rights Commission for the City of Spokane. We were involved in changing the charter in the City of Spokane. I was appointed to the Human Rights Commission by then Mayor Hession and then Mayor Werner. I was appointed to the Ethics Commission by Mayor Dave Cronin and approved by the City Council. I have a history of bipartisan support, which is what a judicial candidate should have, because this is a non-partisan position. And the judge will have families of all flavors, to use a phrase, coming before him or her, Republican, Democrat, Independent, others. And so, as the canons say, the judicial officer has to always be impartial, has to always strive for impartiality, and has to avoid the appearance of impropriety and partiality. So when you go to my website, and I ask you to do that, and take a look at what is there about me and my endorsements, you'll see one thing. I have refused to accept or seek the endorsement of any judicial officers in Spokane County who are not retired. And why do I do that? Well, as the chair of the Ethics Commission, I'm very involved in ethics. And I believe it would be a disservice to my clients to have this endorsement of a sitting Superior Court judge when I'm appearing before that judge. That would be an appearance of fairness problem in my mind. Or the alternative, if I was appearing before a Superior Court judge who endorsed somebody other than myself, what would my clients say as I appeared before that judge? And so I have taken the position that I am not asking for, did not ask for, any endorsements from the sitting Superior Court judges. Retired judges, judges of other counties, I don't think they suffer the same problem. I'm not really here, though, to talk about the 33 years, the many committees that I've been on in the community, the many committees, something like 20, 25 that I've been on in the Superior Court. I'm here to talk about why I want to be a Superior Court judge after practicing in the Superior Court for 33 years in all facets of the Superior Court. We heard from our moderator earlier a brief explanation of what the General Court of Jurisdiction of the Superior Court does. I am an appellate attorney, and I do lower court appeals, higher court appeals, and I've been into the state Supreme Court even. I've practiced in every domain of the Spokane County Superior Court. I safely can say that. Whether it was a practice involving writs, common law writs, writs of mandamus, prohibition, all the ways down to whether or not it's a personal injury case or a medical malpractice case. Criminal felony cases, I've done murder cases, a variety of things that you'll see in the resume. But what I'm doing now is complex family law cases, because the Superior Court in every domain will affect a family in Spokane County, without question. Families are organic systems, and if you believe in family systems, it's like the spider web. You push here on the spider web, there's a reaction over here. You push here on the spider web, there's a reaction over here. The family is affected in a variety of different ways in Superior Court. Not just the family law that can be very complex. Criminal law. If a parent loses their license to drive, it affects the family. A judge has to understand the collateral consequences of what the judge is doing. A probate case. The judge has to have experience in probate, because if a relative dies, it's going to affect the family. Juvenile law. If the family's having problems and is breaking up or having difficulties and they arrive in the court, those difficulties may affect the children. Then the children will be having problems in school. So you'll be dealing with truancy. I was on the board of directors of Team Child, and I have experience with juvenile law. You have the problem with the juveniles in school not going to school and winding up following a criminal path that needs to be changed, whether it's a CHINS, child in need of services, or some other problem that the court has to deal with, and the drugs and the alcohol. You have to have an interdisciplinary understanding as a Superior Court judge, because everything affects the family. I'm the president of the Association of Family Conciliation Courts of Washington State, an interdisciplinary group. It's actually a national group, but I am the president of the Washington chapter. So we deal with mental health. We deal with drug addiction, alcohol addiction, domestic violence, and all these things that affect families. And they affect children as well. Then, as a family law attorney, that is even more complex. When you have a criminal felony case, yes, it's very serious, and yes, we want to protect society, and yes, we want to protect victims. I am a victim rights lawyer. But at the same time, we have to look at what it does to the family. In a family law case, you're dividing the house in a divorce. You have to know real estate. You have to know how to buy and sell a house. You're dealing with a pension. You have to know federal law. If it's a quadro, Qualified Domestic Relations Order, or maybe it's a railroad pension, or maybe it's a federal civil service pension. You have to know tax law when you're dealing with the pensions and the house and the property. You have to know how to divide these now and do it correctly so later on it doesn't come back. You have to have the interdisciplinary knowledge to deal with the problems in the family from addiction, or personality disorders or traits, and how that will affect the child. Because a family law judge, domestic judge decision is a serious decision. I consider the most serious decision a judge can make. More serious than a criminal case, because it's going to have generational effects on a family and on the children, and then on the children's children when they grow up. And so you have to have a sufficient training, an interdisciplinary training. What else does a domestic court judge do? And I've just touched the top of it. We deal with the trauma of the family coming into court. And then we deal with the trauma to the family by the court. I'm a small business owner. I understand systems and paying people and doing books and following audits and doing the regulations. And the Superior Court has a very serious systemic problem, in my opinion, in dealing with families. In 2017, according to the Washington Administration of the Courts, over 27,000 cases were in the Spokane Superior Court. Superior Court. Most of them, 98% of them, involve the family in some way. And now a lot of these families aren't getting access to justice, including the children, because they can't afford representation. They can't afford to hire a lawyer to go into court to deal with the domestic violence or the divorce or the paternity case or the new structure of families that don't get married anymore. And so they're on their own. And when you come up to a judiciary that doesn't have an interdisciplinary training or 33 years experience across the board, you have problems. And when you have a system that traumatizes people already traumatized, you have a problem, particularly when they don't have attorneys. We have a domestic violence court in the Superior Court, and if you look at the way it's laid out, the domestic violence court, you will see it's very, very lethal and dangerous to the people that are in that court. Judges can't even see some of the people because the poles are in the way. And they got to sit the victims, or the alleged victims as the case may be, at this table, and they sit the perpetrators at this table, this close. And then when they have to talk to the judge, they're almost next to each other. This is just one example of the problems in our Superior Court that need to be changed. I'm running to, not for myself, I'm running after 33 years of witnessing this, and something needs to be done. You can't stand by idly and watch this happen. People should not have to pay, in my opinion, $50,000 to get a divorce. I think that's outrageous. But that's the system. There are 3 states around us, Alaska, Oregon, and Idaho, who have created a new way to deal with family law and domestic relations, where they allow the people participating in it to opt out of the traditional way of handling these cases. They try the case without attorneys. If an attorney is involved, the attorney is simply involved to present briefs to the court. The judge will hear all the evidence. The rules of evidence don't apply because the judge is supposed to know them. And the person involved can present the case to the judge as they seem fit. They get fully heard by the judge. The judge can appoint experts if the judge feels they're necessary, and the judge will do that. Or the people can have experts come up, and the judge will question the witnesses, because the judge knows what the judge wants to hear and should hear by law. These 3 states are doing this in one fashion or another. Washington is not. Idaho and Oregon by statute. And it's dramatically decreased the problems with overflow in the courts. And the people are coming out and saying they were heard, and they are easily able to accept a decision, favorable or unfavorable, because they've had their day of due process, and they have been heard. They've been heard completely. They have presented the case they needed to present as they thought they should present it. And attorneys do get involved in that. Now, they don't do that for every case. It's an opt-in or opt-out. You can go with the traditional way, where you have all the rules of evidence, and you have a 3-week trial, and your lawyers are paid $100,000, and it takes a year or 2 years to get to trial. Why in Spokane Superior Court does it take at least 1 year to get to trial in a family case with children who are being traumatized for that entire year? And why should the estate be depleted in that process so that the children then have nothing left for inheritance or college or just for their livelihood? Why is poverty being feminized in the Spokane County Superior Court? Things need to change. I believe after 33 years in the interdisciplinary studies and training that I have, in my leadership roles, not only in the Superior Court, but on the Ethics Commission and on the Human Rights Commission, that I can help bring positive change with the judges, many of whom are not just my colleagues I practice law with, because I'm a pretty old guy. So I'm asking for your votes. I'd love to get questions from the audience today that I will try to answer, understanding that the canons say I have to maintain impartiality and independence, and that's one reason I do not accept endorsements from my former colleagues on the Superior Court, because I practiced before them. Thank you.
Thank you. You take yours, I'll keep mine. Real good. Okay, well, hopefully we'll have time for questions. We'll see how this goes. And our final person to come up and talk is the present judge, Michelle. Her familiar name is Shelley Zambalin. And so Shelley, where are you? Here you are. Very good, stalking.
Thank you. First of all, I want to say thank you for coming out tonight. Judicial races are a little weird. Not many people vote in them. Somebody noted earlier about the lack of participation on the ballot. And I can appreciate people if they don't know, not just sort of throwing a dart at the wall or something like that. But, and I've spoken, shared with some of you here, but there's an organization, there's a website called votingforjudges.org. It's a nonpartisan, just an educational civic benefit that sets forth judicial candidates. It's sort of like a mini version of the voter's guide, but before your ballot actually gets there. So that's an option for you. I'd encourage you to do that. As noted, I'm new to the Superior Court. I'm the current Superior Court judge there, and I can appreciate taking a look at a system and saying, you know, that's not working so well. What can we do to make it better? And that's why I appreciated the opportunity for the governor to appoint me to that, to be sort of a voice of change on the bench. I have over 9 years of experience at the municipal court, where we change the way communities experience justice. There is an emphasis on procedural justice, on access to justice. One of the things that we did while we were, after the court started, was we went to an electronic case management system, which was far more efficient for addressing matters. For instance, if somebody was before the court on a new matter, but that new matter triggered another case, with everything in a paper file, that had to be requested from off-site, and instead of being able to deal with it at that same hearing where everybody was already there, you had to set another hearing. So that kind of taking a look at a new system and saying, is there a better way to build a mousetrap? I think that that's an important thing. And I bring to it collaborative experience in those therapeutic courts, in access to justice, in improving procedural justice. Prior to, I'll hit judicial experience. I have full-time judicial experience not only at municipal court, and where I'm sitting right now at Superior Court. Prior to that, I had 3 years as a pro tem judge in the civil department for district court. Something that I'm really proud of, because as folks have noted tonight, judges have to be impartial. That's why we're limited on what we can say and what we can advocate for, because everybody who appears in front of us needs to know that we don't have our thumb on the scale. And that's why it's heartening to me to have support from not only Larry Haskell, but also the county public defender, the city prosecutor, as well as the city public defender. Having Ozzie Knizovich's support is helpful. I've got people who normally are sitting on opposite sides of the table, and it's because they know that they'll get a fair shake in front of me, and I think that that's really important. I also work very hard. I put myself through college. I was raised down in Phoenix. My dad's a retired policeman. My mom was a stay-at-home mom. We simply didn't have the resources, for that. But I'm a big believer in working hard and making a difference. So I put myself through Gonzaga and then again through Gonzaga Law School. And that tremendous work ethic has served me well on the bench. I sort of get teased sometimes because my car is the first one there and it's usually the last one there. But it's because what we do is so important, and it does require that kind of a work ethic. In addition to my judicial experience, I have served the legal community and the bench. I served as Dean of the Judicial College that Judge Randy Brandt mentioned. I taught on that faculty for several years, for 5 years. And that's basically a statewide school where all the new baby judges go to learn how to be a judge. So that's something that I'm grateful for having the opportunity to have done. And that experience is really important because of being able to hit the ground running. I was sworn in at 8:25. I took a felony plea at 8:30, and I started a 3-day trial right after that. So having that experience is really helpful. It's sort of the bane of my existence right now because one of the most challenging dockets is the chief criminal docket, and the most challenging day is Monday because all of the people who have been arrested over the weekend need to be seen. So it's basically a double docket. And whether you notice or not, I know that Lyndon and Patrick will know, there tends to be what we call this, at least what I call the summer burp, where there's an increase in cases over the summer. So it's the most challenging docket, most challenging day, the most challenging time of the year, but they've asked me to cover that. I'm heartened also that because of my prior experience in therapeutic courts, that I've been asked to cover the what they call the ECR docket, the early case resolution docket, as well as drug court and mental health court for the rest of the month while Judge Clark is on vacation. So that experience matters. It's also been acknowledged by organizations that look at things like this. When I was being evaluated by the Spokane Bar Association, they gave me their highest judicial rating. Same thing with the Washington women lawyers, exceptionally well qualified is what they rated me at. The Spokane County Bar, the rating that they gave me references how I set the standard for excellence in the areas that they rate. So I bring a lot to the table in addition to the judicial experience. I have over 27 years of legal experience. I was an appellate prosecutor for a number of years. I have about 15 reported opinions and many, many more unreported ones. It depends on whether or not it has precedential value, whether or not it gets published. I practice at all levels of state and federal court. Prior to going to the prosecutor's office, I was in a complex civil litigation practice where I did all kinds of really fun stuff like aviation law and all kinds of things. And I see you over here, so I'm mindful of the hour. So I appreciate the opportunity to come talk to you tonight. I came straight from court, and so I spaced my Slim Jims or the palm cards. But if you go to friendsofjudgeshelleyzamblin.com, you can find anything you want to know about me. But again, thank you very much for the opportunity to be here tonight.
Okay, you know, somebody asked me who's keeping time, and what I really wanted to do was respect all of you for coming out here. There's no point of cutting people short when you've made a trip to learn about these folks. So hopefully you agree with me, but I don't think that we need to be saying off with your head because they're taking a little bit longer than we thought. Maybe our questions will be a little shorter. We'll just have to see. So now what I'm going to do is ask Beva Miles and Brian Standow, both of the Spokane County GOP, to handle the question and answer portion of the meeting. Beva also is a member of the RSC Club. So I saw there were 2 chairs up this way. You might want to position yourself there, or you might want to, I don't know what you want to do. So yes, so all of it, no, you're going to stay there all by yourself. So all of you guys put district court over here, superior court over here. And you know, one thing that I really was listening to was, first of all, look at the impact that Gonzaga University has in our community. Pretty darn incredible. And you know, yeah, please give them a hand. I mean, just wow. The other thing that I was thinking of was, you know, all of these people have a nice, optimistic outlook. They smile. They look like they're okay and all together and the whole thing. But when you really consider the elements of society that they listen to, that they're involved with, some of the issues that they're concerned with, I think it's pretty remarkable that they can still function as what I call a normal human being. So my hand's off to you guys. So we have a microphone here, and I'm going to have a microphone on...
Okay, I'll meet you.
I am. You're going to have a microphone on the other table, and I'm going to give Brian my headset so he can speak also, and we'll be all set. So where's the other microphone? All right. So hi, everybody. Did you get something to eat? Are you like just raring to go on this exciting evening with judges and court systems? How many of you have any experience with the court system? And I don't want to know what it was, but how many of you have experience in the court system? How many of you were satisfied with the experience in your court system? All right. How many of you know somebody that was in the court system? All right. How many of you are satisfied they got what came to them? What I want to do is I want to talk to you a little bit, because we found out when we got involved in politics that most of our legislators are just the nicest people, and they're just people. You get to know them, you get to talk to them, you go to them, and I'm finding that judges are the same. The black robe doesn't change them from being a unique human being. So I'm going to start tonight with a little different look on things. I want to talk about a human side to these judges. They see maybe not the highest grade of humanity every day. They see tragedy, they have joy, they see people that have made it despite of it. So I want to just kind of start, let's start with you, Mr. Cronin. Let's talk about just in legal experience at all. Do you ever wake up in the middle of the night thinking about a case, wishing you had handled something differently or regretting something that happened?
So, is this working?
Yeah.
So one of the joys of my life is that I've learned after 33 years that 2:30 a.m. is when I wake up. I say, oh my goodness, I have to do this, that, or what have you. What you try to do is you try to be so committed and prepared for your clients that you don't wait to the last minute to do something, that you're ahead of it weeks ahead of time, so that you are giving yourself the opportunity to change course should that need to happen. And you need to make sure that the client is equally involved in the decision making. As a Superior Court judge, you can do that as well. You need to make decisions, and you need to have some finality to your decisions, and that's what I was taught as a commissioner of the Superior Court. And then if there's going to be an appeal, there's an appeal, or there's going to be a review, there's a review, but you have to have confidence in your decision, and to do that you have to be learned, and you have to give the decision the time it deserves, and not just make a decision because of expediency. And you have to be able to talk and seek the advice of your colleagues, as well as the people that are before you. Now, there are different domains, of course. So with a criminal case, you can't really talk to the defendant as the judge directly, but you can talk to the defense attorney. One thing that in criminal court always amazes me is that when they come up for a plea, on the plea docket, they want the judge to make this momentous decision to accept this plea of guilty to some charge. The prosecutor says, Judge, we've got the amended information here. We're reducing the charge. We're here for a plea. Judge, thank you very much. Defense attorney, do you agree? Yes, I do. Judge perhaps should say, in my opinion, to the prosecutor, why are we doing this? Explain it to me. I'm not here to rubber stamp it. I'm not here because my docket is so long that I want to get this in and I want to get it out, because I got a human being here and I have a human victim as well. And this is who we're serving, not the expediency of a large docket. We got to keep it moving. And the judge should be able to say to the defense attorney, Why does your client agree to do this? Why is your client agreeing to go to jail, as the case may be? So when you ask the question about decision making and do I worry, of course I worry, because in that scenario I'm making a decision with less data than perhaps I should have, relying upon other people's thought processes that perhaps I shouldn't do. And so if the system can't handle that type of functioning, we got a problem. And the system needs to change. And then perhaps I wouldn't wake up at 3:30 or 2:30 in the morning and say, oh, I don't know about that plea I just took, because I just thought of A, B, or C.
Pass it. No. Thanks. You know what, Shelley? I'm going to ask you a different one.
Okay.
Describe your most difficult case.
As a judge or a lawyer?
It doesn't matter. Most of you have legal experience prior to being on the bench.
I think the most difficult cases are the ones where you're making a call that might be unpopular, but you know that it's the right decision and you wouldn't change your decision, but there's blowback because of it. I mean, so, and we see a lot of trauma in front of us. You know, Mr. Cronin's right. I mean, people are not in court generally, regardless of whether it's civil or criminal. They're generally in court because something is wrong, and we don't see people at their best. So, you know, that when you have to make a hard call, but you know it's the right call, you prepare so that you're confident in your decision, but at the same time you're a human being. But you see that the trauma, and
do you recall a specific case?
It might be going up on appeal, I don't know.
Okay,
So
we won't talk about it then. Let him pick up the mic there. Thank you, thank you. Let me ask you, what's your greatest accomplishment? I know you've had a long legal career. So what, Judge Brandt, is your greatest accomplishment, and in your personal life as well?
Being a good son.
Being a good son. Good answer. Good answer.
You know, I had the opportunity to care for my mother in her final days with Alzheimer's, and my father's final days. Being a good son, and that's would be my claim to fame.
And that's the human side. Thank you. All righty. Let's go down one more and say, what are the major influences in your life and why?
Wow, I've had a lot of good influences. In fact, one of them is sitting right here, black dress, toward the back. My wife, Dana. My wife is a lawyer, and you would think that that would be prone to difficulty, having two lawyers married to each other. But I can't tell you how relieving it is to get done with a tough day and be able to bounce ideas or thoughts or frustrations off somebody who gets it. And my poor wife is pulling double duty here. She's my campaign manager as well, so that has to be an accomplishment in itself to get, as we know, campaigning is not easy and it's all-consuming, so I thank you. My wife has been a great influence. I'm influenced by my parents. My dad worked construction. He worked hard for us. He is a kind of guy who would go around, and if there was a construction project and somebody needed to know how many cubic yards of cement are you going to need to fill a cylinder, he would do the quick math and knew how to do it. He worked hard. He was a guy who went to work at 6 a.m. He'd come back after dark. His boots would be covered with cement. And so there's a lot of work ethic to be gained from that. My mom, very much supportive. I always think back on this. My first words were something to the effect of, good boy. I couldn't say it. It was Bob Bob. But my parents were so supportive and really told me that I could do anything. And I believed it. And maybe I shouldn't have all the time, but I believed I could, and so I'm greatly appreciative for the influence of my parents, and you know what, even my kids. I've learned a lot from my kids. My oldest is in college at WSU, just finished up sophomore year. The other two are 16-year-old sophomores, and they teach me things every day about the world and people.
All right, Mr. Smithson, who are your judicial role models and why? And tell us about Brett Kavanaugh while you're on there.
Pass. Sorry. My judicial role models? Well, I have quite a few. I've got a couple judges that are helping me in my campaign, so they're actually very influential. They're helping me out with my campaign. It means a lot to me. Judge Hayes is a district court judge that's helping me in my campaign. Judge Staub is a municipal court judge who is helping me on my campaign. And she's actually probably the reason that I'm here. Judge Staub approached me last year, November-ish, if you will, and she said, you know, there are going to be some openings on the district court bench. I think you'd be a good fit for that. I think you have all the qualities that we need on the bench. You're thoughtful, you're compassionate, at the same time being a prosecutor, you know when to get down and dirty and really work hard. So that was impressive. I appreciated that. I was humbled by that, and I started that process back in November, talked with lots of other judges before I made this jump, and that's kind of where things went. I'd rather not get into talking about any other sitting judges just because we are running for judicial positions and we're supposed to maintain that impartiality.
Well, yeah, but he's the nominee for the Superior Court.
He is.
Pass. I get it. Pass, did you catch that? Pass, okay. Okay, that's really neat because we all see you as human beings with families, with devotion to your chosen career. So let's get into something a little deeper. Let's jump into something this room's going to stand up and listen about, okay? Each one of you, and we'll start. The reason I told him to put that up because I can't say Zambellin without looking at the spelling. I have to be honest with you, Shelley. That's great. So let's start with you since we started with Mr. Cronin before. Ms. Zambellin, let's talk about major issues involved in the debate regarding gun control. What do you see as the major issues in the debate regarding gun control? And then we'll pass the mic and come back and end with Mr. Cronin. Each one of you need to answer that specific question.
Okay, I think we probably all have the same answer, and it's kind of like what I had explained to some of the people that I was chatting with beforehand. The Code of Judicial Conduct really limits us on what we can talk about. For instance, if somebody who's a sitting judge or a judicial candidate comes out as advocating for one position over another position, and then for some reason that issue comes before them, obviously the person that's on the other side isn't going to think that they're going to get a fair shake. And so that's part of why we're really limited on what we can do or say, especially for hot button issues. And I know that that's frustrating for people who are wanting answers, but we're pretty limited in that regard, and it's to make sure that we're impartial. We can say we can I took an oath to follow the law, and I'll follow the law, but aside from that, I'm pretty limited on what I can say, and I'm sorry about that.
No, I expected those answers, and that's fine. I still want to give each of you an opportunity. No, let's go this direction. Mr. Cronin went first last time, so we'll go down here to Judge Brandt.
You're on. You turned it on. It's on. There's a power switch and a music button. What did you just turn it on?
I didn't want to be there.
All right, thank you. Shelley is exactly right. We have judicial issues, what we can discuss. We're not legislators. I should probably shut up right there. We, as a judge, I'm sworn to uphold the law, to hear the facts, hear the evidence, sometimes get excellent briefs from the counsel, from the attorneys, and make a decision based on the law. So when we put on the robe, we take off our bias, And so Shelley's right. I'm just expanding in a little bit different direction. But there's laws that I may not agree with, but as a judge, I'm sworn to uphold what is the law.
It's a tough question, isn't it? You guys want a direct answer. You want to know how we feel about guns. And you've heard answers that are entirely legal and appropriate. And that's frustrating. Sometimes you have to infer certain things from other known facts. I will tell you that I am endorsed by the Republicans of Spokane. I am endorsed by the Sheriff's Office. I have been in the military over 25 years. You can probably guess that I have a certain familiarity with guns. I also teach a class at sharpshooting. The class is firearms law and you. So I have some basis of knowledge here. I'll tell you what, the Second Amendment applies throughout the land, and the Heller decision, Heller versus DC, not only said the Second Amendment applies, but it applies to individuals in their capacity to carry a firearm. That is the law of the land. That is the law that I will follow. You know what, though? If the law changes, I am sworn to uphold that as well. Thank you, folks.
Thank you. To me, gun control means hitting what you shoot at. That's about it. I have my concealed weapons permit. That's all I can say personally. I don't want to talk too much about it because, as everybody has stated before, it's not an arena that we are allowed to talk about as judicial candidates. Thank you.
All right. Mr. Cronin.
Well, we hit a milestone here. We got 5 people who all agree. This is just amazing. When I take the oath of office is going to say that I swear and affirm that I will uphold the Constitution of the United States of America, the Constitution of the State of Washington, and do my best to impartially perform the duties of my office, which would include the enforcement of all the statutes in Washington State. I'm aware that the federal law on guns is supreme, and I'm aware there are issues. There are issues with taking guns from people because they're mentally ill, or not taking guns from people because they're mentally ill. We could go on and on about what the issues are. Spokane County Superior Court on these issues does not make law. That is correct. They do not legislate. The courts of appeal above, in Division 3, 2, and 1, and the Supreme Court will address the decisions of the Spokane County Superior Court, which are based upon the law and stare decisis precedent. We are not a legislator. I can tell you that guns are a big issue. They're issues in family law cases. They're issues you can't even get through the court doorways without being searched without a warrant. They put up this metal detector that you have to go through. And where's the warrant? Why are you focused on me? What do you think I'm going to do? Why are you searching me? And so these issues and that's there because, partly because of issues with search and seizure, but enforcing constitutions and what the constitutions say, and guns. So I agree with what everybody said here. It's a very important issue, but I will follow my oath of office. Thank you.
All right, Mr. Grant, we'll start with you this time. We talked about the Constitution. This is the Second Amendment that we just spoke about. Your oath will include a statement of upholding and preserving the Constitution of the United States. When is the last time you undertook a serious study of the Constitution, and can you identify 1 or 2 areas where you feel the Constitution is being violated today?
Can we talk about loaded questions?
I am just full of them.
As a judicial officer and as a lawyer, again, I'm sworn to uphold the Constitution of the United States. Whether I disagree with elements of the Constitution of the United States or of Washington State, is something that I think is a privilege that I hold. And like I said, until the citizens change, if there's amendments, then I'm going to stand by them as they are, because it's the law. And so for me, it's an easy response. We stand on what the forefathers brought, have changed somewhat, but are still there and are still good law. So, I read the Constitution from time to time, and I've been honored to give presentations to the young people who are becoming Eagle Scouts on the different areas, the separation of powers that protects us all, and of the Constitution. I go through different elements and the amendments in the Bill of Rights, and so it's great to help young minds learn that with my experience.
As a prosecutor, I am in situations where I see the Constitution being violated, and as judges hear these motions. They hear when there's an allegation that the police violated somebody's rights, didn't give them access to an attorney, didn't advise them of their Miranda warnings. And the duty of a judge is to listen to those claims that there's been a constitutional violation. And you want to know that as a judge, that person is going to weigh not only the rights of the police and the community, but weigh rights of individuals. Because we are a land of laws. We are a land that is driven by the Constitution. And as a prosecutor, the ethical rules actually refer to us as ministers of justice. That is written into the code. And that tells us we are more than just advocates. So if I see an issue, a constitutional issue that somebody brings to my attention, as a prosecutor, as a minister of justice, I have a duty to act on that. If I disagree and think the Constitution hasn't been violated, you bet. I'll file that response brief and argue hard. But if I believe there has been a violation, I'll dismiss that case. I do that as a prosecutor, and as a judge, I will listen and follow the law as well.
Following the Constitution, I can tell you every single one of the people up here are hard, fast, and would probably go to battle to defend the Constitution. I know that because they're lawyers. I've worked with all these people on this panel, and all of us are extremely serious about the rights of our clients, the rights of individuals, the rights of everybody in our society, whether they are the lowest person on the sidewalk that is begging for change, or they are the richest person in the county and they're coming before the courts. I know that every single one of the people on this panel believe that same thing. As Patrick alluded to, as prosecutors, we hear these cases all the time. We have situations where people have claimed that their rights have been violated. We have the power. The prosecutor is probably the most powerful person in the court system. We can dismiss cases. If we know that, if we find evidence or we see evidence from the defense that a officer did violate the rights of somebody, we have that power to dismiss the case. Sometimes we don't necessarily agree with their information, so it does go to motion. It goes to motion before the judge, and the judge determines ultimately what occurred. And also we deal with case law on a daily basis, and case law oftentimes is looking at the Constitution and interpreting it, and cases that come before it, precedent, we have to rely on those. So as a judge, I will uphold the Constitution. I will uphold those cases that have come before it and have interpreted the Constitution in the past. Thank you.
Okay, I'm going to switch it up. Now we're going to move over to the Superior Court side here, and I'm going to ask a question kind of along the same lines but a little outside. What criteria would you use for deciding whether to impose or affirm sentences that are outside of standard ranges?
Well, in Washington, we do have what are called standard range sentences, where you have the legislature has passed these sentences, high end, low end, for different crimes based upon criminal history, which is theoretically supposed to then prevent a judge from exercising discretion where that some people will get a completely different sentence on similar facts than somebody else. That sentencing guideline, though, also has built into it an analysis to go below the standard range on particular facts and circumstances that may exist, such as, for example, a failed defense where the defendant had, let's say, pled self-defense in a crime and didn't prevail, but the facts were such to justify a low-end sentence and then an exceptional sentence below that. You can also have an exceptionally sentence higher than the grid. And the way the law is progressing, if the state wants an exceptional sentence, you have the right to a jury trial. I argued one of those cases came out of the Supreme Court of the United States, and it changed federal law. I was part involved in that. It was the Blakely case, and we were in eastern Washington in Grant County with Judge Spurline. I didn't go all the way, but in the beginning of the case. And so Blakely and its other cases that are part of that said you get the right to a jury trial on that. And so that depends, though, if the prosecution is going to ask for an exceptional sentence. And sometimes the prosecution won't do that. So there's a very detailed analysis on sentencing in Washington, very complex, that could not be properly addressed other than just in the generalities here today. But we will follow the law. We will follow the sentencing guidelines. Lastly, that's why it's so important, as I was saying earlier in criminal law, when you're doing a plea, particularly with the collateral consequences that can affect the family in so many domains, the judge should not just sit there and say, well, what's the agreement? Low-end standard range, Your Honor. High-end standard range, Your Honor. Standard range, Your Honor. Okay, thank you. You need to ask, how was the thought process that came to that? And what are we doing with this defendant and the collateral consequences on society and its family, as well as the victim, and principles of restorative justice? So that would be my answer.
My answer would be pretty similar as well. At the Superior Court level, there's the Sentencing Reform Act, and it's a grid that looks at the violence level of the crime to which the person's being sentenced, and the person's offender score, which is based on their criminal history. And that in and of itself can be complicated because some crimes wash out, some crimes there's a case called State v. Ford where the prosecution can't prove that that conviction should be used in the offender score. It's so complicated that the guideline for applying it is over 800 pages long. But the concept for it is that they call it discriminate sentencing, to give some sort of framework, the standard range. If a judge sentences to somebody into the standard range, there can't be an appeal of that sentence. And that's one of the collateral consequences that you advise folks, is that you understand that if I follow if I sentence you to the standard range, you cannot appeal. And like Mr. Cronin referenced, there are statutory criteria that's non-exclusive that talks about the circumstances that are considered for an exceptional sentence upward or downward. And so you have that framework to guide your decisions.
I have a clarification for everybody because it's been brought to our attention. So because you two are the only two on the ballot, you're obviously the top two, and so you'll appear on the November ballot. Is that correct?
Correct. We're not on the primary ballot. We go straight to the general.
And you're both for position 10.
Correct.
Correct. I think I had a mistake in one of my slides, so just wanted to clarify that for everybody. And might have another question too, but then we'll go to questions from the audience.
Actually, I do want to go to questions from the audience because this is about you making a decision, and you will have other people who are going to call you and ask you for your advice on making decisions. If you don't, you're not talking to people enough.
So I'm going to come with this little microphone, so raise your hands and I'll run as fast as I can.
Well, hang on a second. We got one more thing I want to do. You'll notice as I questioned each one of the candidates, and some of the questions were loaded. And I want to give this to you straight up before you ask questions, because they have the right not to answer. Canon 7 is very specific that they should not announce their views on disputed legal or political issues. They must be apolitical arbiters of the law. They are not only expected to be impartial, they have to appear to be impartial. So as you ask them questions, please respect their ability to say no. I have a good sense of humor about it. I'm told no all the time. So if they want to say no, that's fine. But there are certain things they cannot give an opinion on. We touched on gun rights, Second Amendment. So as you question, keep that in mind. Taking questions from the audience now, the people are on the screen, so you know their names. You may ask them individually or as a group. Anyone? Gary. Right up here too. Well, Gary Edwards first, I guess.
Hi, my name is Gary Edwards. Over the years, I've been a bonded conservator for over 3 decades in a particular case, so I've sat in courtrooms quite a few times. Most of the situations were resolved, but it's educational to watch. And one of the things I've noticed in courts in California, in particular, it seems to have gotten worse in recent years, is what they call guardians ad litem, the use of them. And the money that they got paid for doing very little work and doing more damage to the questions than their use. What is your experience in using guardians ad litem in this area?
Whoever wants that one, grab it. Let's move it along.
It is a problem. As the president of the Association of Family Conciliation Courts Washington chapter, I've been involved in trainings for guardian ad litems and in the formulation of policies and manuals regarding that. I'm on the Spokane County Superior Court Guardian ad litem Committee. Previously was a guardian ad litem, and there are quite a lot of use of guardian ad litems in Spokane Superior Court. It is a problem getting qualified people to be guardian ad litems that have an interdisciplinary understanding of what's going on in a family or with whoever the person the guardian is appointed for. The guardian's not necessarily an advocate. 2609-175 says their duty is to investigate and report to the court and not advocate. And sometimes guardians fail to understand that it is their duty by statute. The cost is sometimes prohibitive. And you have attorneys that are very competent attorneys to prepare a case, and yet they will default to a guardian ad litem. The court doesn't have to follow the guardian ad litem's decision, recommendation, or opinion because the court is autonomous and independent. Sometimes, though, you wonder if, out of expediency, that's what's happening. Luckily, this month, the guardian ad litem rules and training have changed, and they're coming to Spokane County. They just had the pilot project over in King County. Our local commissioner, Commissioner Michelle Ressa, is very involved in that, and it's coming to Spokane County for training, new guidelines for guardian ad litems across the state of Washington. So you have a correct, in my view, observation that it is an area that needs focus and attention and perhaps change, and Washington's Supreme Court Administrative Office of the Courts is trying to make those changes, as is other organizations like AFCC.
Thank you. Any other questions here? We got microphones, sort of.
Hello. All right. My name's Don Davis, and I have a question for Shelley and Dennis about the current CHINS in our court, how CHINS is working. When we have a child that finally makes that brave decision to go through that process, what are your thoughts about how well the child is represented in the court system when you have a child versus maybe a parent or an abuser that is responsible for them, and what are your thoughts of their representation that they get?
if I heard you correctly, it's CHINS, Child in Need of Services. This is a juvenile case where the child has approached a juvenile court and most likely in cooperation with a counselor at school perhaps, has filed a petition because there's problems at home and they want an out-of-home placement, or they want some other services from the juvenile court. And in Washington, when a child turns 12 or 13, the court has to advise the child that they may have a lawyer appointed for them. The case laws come out and said from the courts of appeal that says they don't have a right to a lawyer, but a lawyer can be made available to them, and so some counties do that. Other counties do not. And when you're having and usually in Spokane County, it's the public defender's office or the contracted public defender's office. And the dynamic is on the one hand, you got the parental rights, to raising your children under the First Amendment, and to make decisions for your children as a parent, in tension with the child at that age, and under various state statutes can make decisions such as health care and abortion and other things that the parents can't get involved in. And then the lawyer that's appointed is not a guardian ad litem that's making a recommendation, but is an advocate for the child. So the lawyer is supposed to be presenting the child's view. Now we know from brain science and the studies in brain science that children at 13 years old haven't had their brain fully formed yet. And the brain isn't fully formed until about the age of 25. And yet the children are making these very momentous decisions about family. And in abuse situations, it's even more complex because you do got to recognize the abuse and you got to get in there and protect the child, particularly because the child is not mature enough. And the children come in different, some are more mature than others. Some appear mature but are not mature because of the biology in the brain. We don't let children drive a car until, what, 16 if I recall correctly? 21 in a lot of states is the age of majority. Here it's 18. Can't get married before 18. Over in the family court, a child at the age of 13 doesn't make a decision as to where they want to live, and they don't get a lawyer to represent them in family court. In Ray Marriage of King says you can't get lawyers appointed free in family cases. But then over in the juvenile court, you have this dichotomy where you can have a lawyer appointed, but it's not a right, but you can have a lawyer appointed, and they are appointed, and then they advocate for the child. And so the judge has this tension in juvenile court. And then the CHINS petition only lasts so long. And after 180 days, if the problem hasn't been resolved, it's dismissed. And what have you done? And there's a question in the law whether you can have serial petitions. So the answer to your question, sir, is it's extremely complicated on several levels. And I don't know that we have an answer, but as far as a lawyer for the child, that's somebody who's advocating for the child, bound by the RPC's, Rules of Professional Conduct, to do that, even if it's not in the child's best interest.
Thank you. I have a question for the district court judges, and I've heard, so I'm not sure if what I hear is correct, but I hear that you guys have a tremendous workload of cases and that there's a backlog in cases and that we're expecting you to work miracles. And so number one, is that true? And number two, do you have any suggestions as to how we can get these cases moving through the court system more quickly and having these things handled, dismissed, and out of there so people can get on with their lives and all that good kind of stuff?
Thank you. I'll start out and I'll hand the microphone off. District Court does have a lot of cases. It has about 10,000 civil court filings. It has about 6,000 or more criminal filings every year. And when you start mixing in the infractions, which are speeding tickets or red light tickets, those types of things, it swells to about 50,000 cases. Currently, there are one position is open, so a little bit of that is going to be alleviated just in January by one of the judges taking a bench that hasn't been in that position for the last year and a half or so.
So how many positions are there that handle these 50,000 cases?
There are 9. And so there are 8 judges currently. There will be 9 on January 1. So that's going to help out a little bit. Besides that, the more we put officers on the streets, which is a good thing, the more cases are going to be referred back to our courts. And I will tell you that I'm committed to work hard to get all those cases resolved, get all those cases through the court system, and I will give everybody a fair hearing and hear everything that they have to say before I make my decision.
So you're off to Patrick. Patrick, we sort of heard that. Do you have any suggestions of how we can alleviate some of this? How can they be handled more quickly?
Yeah, that's the rub, isn't it? How to give people justice, give them a lot of justice, and do it in a little bit of time. We need to do that to not only be fair to people, but to lower the burden on the taxpayer. You guys are the ones who are funding all this. You guys are filling the jail. So how does somebody who would be in that judicial position conquer this monumental task? And I'll tell you what, it's not easy. I will tell you, my thought on the matter is, the judge who takes over this position is going to have to know the difference, going to have to get there fast, make a quick decision, but one that is fair. And how do you do that? It's based on your background. In my case, I have 20 years of being a prosecutor. Before that, I did thousands of misdemeanor cases, defending them with the City Public Defender's Office. I have 17 years of defending soldiers. So those are skills I would draw upon to make a quick but fair decision. Everybody needs to get their fair shake, but we need to do it efficiently. We need to move it along. You don't want a judge who has to ponder and think about what is that rule that is shaking around in the back of my head. You need to have that split-second decision-making capability. Structurally, in terms of fixing district court, boy, we've tried a lot of things over the years. There's the courts are divided into what they call the alphabet courts to try to just divide up the docket and throw it to judges on the bench. Look, folks, I don't have a good answer to tell you other than the people that you put in those positions have to know what they're doing and hit the ground running.
He's right, and I'm the guy that can hit the ground running. I've gone through all the judicial colleges, the state, the national. This isn't prospective for me. I've done all these dockets. One of the big advantages our community has is that early case resolution docket that we've talked about, where we have resolved routinely 80% of the cases coming through the door every arraignment day. The judges on the district court have a different rotation than the Superior Court. We used to flip-flop them, and so we're on 24/7. We're on for all week. And if they need a search warrant or something like that, so that computer program that I mentioned earlier is part of my effort to make it, to expedite the handling of a case so that it reduces jail costs or incarcerations when it's appropriate. And the fact that we expanded on the district court, I think the superiors did too. We used to come in at, let's say, 3 o'clock on a Sunday, and we'd work until all the cases of those arrested from noon on Friday were heard, to consider setting a bond, setting release conditions, releasing them on their own recognizance. Well, we expanded that to include Sunday. So, that meant that the people that were being arrested would not sit in jail, and so that's part of their access to justice. And one of the big things, the big bells that I've been ringing a long time is the Therapeutic Courts, the mental health docket that I had. I was the presiding of that docket, and the domestic violence dockets, the Veterans Court that was mentioned. And so it's a way of touching people sometimes 1, 2, 3 times a week. So it helps them, it gives them stability, it gives them a structure that they may not have. They may be living on the streets, and when they come into the therapeutic courts, they're given a structure. They're given guidance. We used to call it wrapping them with services. We make sure they had housing. We provided bus passes for those who had transportation issues. We would make sure they were fed, that they had, through the Chaz Clinic and things, that they had health care. So these are all things that go to that access for justice for anybody that needs it. And so to come back around, it's just a continual commitment to provide an access to justice. So Mr. Johnson is correct. It needs to hit the job running, and I don't have to go back to a judicial college. I don't have to buy another row. I am the one that can hit the ground running.
Thank you. Questions? Anybody have their hand up? Well, then I'm gonna ask one more question, because many parents have experienced an angry child saying that they're going to claim child abuse because they're angry at you. And we've also seen adults use lies to get restraining orders. What are done to people who basically lie to a judge in order to get a restraining order, but then is eventually dismissed because there were no grounds for that order?
I'll jump in. I had the restraining or no contact order docket for a long time, and with years of experience, you can kind of cut through the chaff. It doesn't take a long time to figure out if somebody is blowing smoke at you. There's a certain, the judge can ask certain questions, probing questions in the sense of fleshing out the facts.
I respect that, but basically now what's happening are people filling out restraining orders, a clerk takes it, a stack of them, the judge signs them, and then 3 weeks later the people get to be before a judge after their life's been pretty well destroyed.
Period. Yeah, there is an issue, and I agree with you, there is an issue that there's a presumption to grant a temporary restraining order and set for a hearing in 2 weeks. That doesn't mean that they're going to be rubber stamped, at least by this judge. I never did. I refused a lot of temporary order requests.
So my question was, what do you do to the person that falsifies the charges in order to have you sign that initial restraining order?
It's a perjury issue. Then you look to the prosecutors to go after them on a criminal charge, because the document provides a provision that they swear that the information provided is true and accurate, and it's under a penalty of perjury. So if someone lies on an affidavit or a petition to a court, if they lie on it and they're caught at it, and the prosecutors have the discretion to go after them.
Oops, sorry, go ahead.
No, that's right, sure.
And just by way of background, they do in fact do, because I had a very hotly contested domestic violence case that involved that very same issue. If you believed one side, the person was this manipulative, evil person that's been beating up on their spouse all over, their respective assignments in the Air Force. If you believe the other person, it's a vindictive ex-spouse who's trying to get an angle in the dissolution, and it was very, very hotly contested. And ultimately, it was discovered that the one spouse was caught via email, encouraging, admitting that it didn't happen, and telling her adult daughter to, sign the declaration that said that it did. And my case went away because Patrick Johnson's office pursued perjury charges against the person who falsified the information. So it's not like it's not an empty. An empty threat, or just like it's an option. It's a real option.
Yeah, I appreciate that, because unfortunately people do like to take advantage of the law. Other questions?
Yeah, my question is one thing we haven't talked about here. A little bit it was mentioned, but victims. When you have a family member that's a victim, and there's a plea bargain, maybe the victim didn't want that. What is your guys' position, if you can state it, on plea bargaining and victims, and how do you respect victims when they actually do show up in your court to see that those plea bargains are enforced?
If I could jump in on that one. As a prosecutor, I've been in that position. I prosecuted sex crimes, 2 separate rotations through our sex crimes unit. and I am familiar with the legal standard. What happens is that a prosecutor has a duty to consult with the victim. Now, consult doesn't mean the prosecutor has to do what the victim wants. Consult means to get feedback, to get an understanding of what the desires are, desired outcome of the victim. In many cases, victim wants the death penalty, and it may be a simple assault. And as a prosecutor, you have to tell them, no, that's not on the table. You can't do that. More difficult discussion is when a prosecutor believes in the crime, believes that this crime has happened, but has to have that tough discussion with the victim, look him in the eye and say, you know what, I believe you, but the facts aren't there. I'm going to get what I can out of this case. I'm going to get some accountability instead of losing the whole thing. And that's a discussion we would have. And you know, most people are pretty understanding, but sometimes people are upset. They're upset that I am not doing what they perceive to be my job, but I've actually been in that position. And it's tough, but the legal standard is consult.
How have you been able to follow up on the plea bargains that you did?
To see,
I see a lot of plea bargains being done, but I don't see the enforcement of those plea bargains.
oh,
And prosecutors change. So there's no enforcement. So plea bargain may be the right thing.
Right.
How is justice carried out in the long term?
right. So yeah, 95% of our cases are plea bargained. If they didn't plea bargain, the system would grind to a halt and nothing would get done. As far as follow through, I can tell you, as a prosecutor, once the ink is dry on the paper, it's off my desk and I move on to the next case. I have nothing to do with the enforcement of that plea bargain. Now, if we're lucky, it's a victim crime where Department of Corrections is involved and monitoring somebody to see if they messed up. Now, if they do, they get arrested, they may have to do more time on that plea bargain. But as a broad proposition, yeah, once we're done in court, it goes off to somebody else.
What would you do to change that?
Oh, what would I do to change that?
Adjustments, right?
Well, look, I don't know that I want prosecutors monitoring cases. That's just not their job. You want your prosecutors to be in court to do lawyer stuff. I believe that Department of Corrections is the best resource.
When the case comes back up for review, when there's a violation of the plea agreement, then you, instead of seeing the same prosecutor from before, they send another prosecutor. Then they send another prosecutor. We're only talking about when it comes back up for review, so the prosecutor that shows up is not prepared for that case. They're barely familiar with it unless the victim shows up.
He's talking about continuity within the case. Yeah.
So, and that is one of the issues in district court. District court puts people on probation, generally for 12 months or 24 months. And your probation could be that you can't have alcohol if it's a DUI. It could be that you can't have any new criminal law violations. It may be that you have to go to some sort of treatment. And you're correct. If somebody doesn't do the treatment that they're ordered to do, the courts will notify them that you're in violation of your probation. And the probation department are the ones that notify the courts. And so you're right. Then the prosecutor has to come back and they need to know the case, they need to know the history of the case, they need to know what the person is supposed to be doing, and if they have the time, they check with the victims to see if anything has changed in the house, if let's say it's a domestic violence type case. But generally, our cases we're pretty overworked, we don't have that luxury, and in my unit, in the domestic violence unit for the city, we work very hard on those cases. We try to make sure that people stay in contact with probation, that they stay in the classes, and hopefully they get out and don't have those issues. From the bench, I can assure you that I've dealt with those issues. I will deal with them when I'm on the district court bench, and I will hold people accountable for the plea agreements that they take.
Okay, well, I think we've really worked the heck out of you guys tonight. It's getting a little late. I will ask one more time, are there any other questions from you guys? Because you've spent your time. Gary, I'll ask you to keep it short, because Gary likes talking for a while.
One thing we've seen, that you've probably all seen, is a distrust of the legal system as a result of situations that have happened in our nation. And they've also distrust of law enforcement, FBI, FISA, things like that. Now, that's big time, but it has diminished respect for law, judges, lawyers. We have people like Ginsburg on one extreme, and we have the other extreme, two different schools of thinking, one which likes United Nations laws rather than the Constitution. How do you address the distrust that has developed the last few years on intelligent voters and public? Do you like social justice or do you like the law?
Really quick.
So, one of the things a judge, in my opinion, should do is, in Spokane County, come out of the castle and get into the community and be involved in the community. So that one of the reasons we're here today is a lot of people don't know what judges do and don't know judges. And you don't see the judges, and they're not out in the community. A judge has to be impartial, a judge has to be independent. These are true canons, and avoid the appearance of impropriety. But they can also be working in the community to assist understanding of the law, to educate about the law and what their duties are, and to promote positive developments in the law. And that does not affect their ability to be impartial or independent. And I think you may have observed that in Spokane County, particularly in the Superior Court, the judges do not get out in the community and be heard and try to educate and try to bring change. They do their 5 a.m. or whatever when they get in, and then they leave. Some, like Ms. Amlin, work real hard, and she does, and that is correct. But then they go home until there may be a challenge in an election, and then they come out. Because incumbency, after all, they don't like being challenged in an election. And so even if there isn't, like Dick Leland, even though he doesn't have an opponent, he comes out and he talks in the community, does he not? Because he understands that you may be a judge, but you also have a duty to be in the community.
Quickly.
Randy?
That's why it's important for a judge to serve in community efforts, campfires, Exchange Club, Lions Club, to be involved in all these city and county activities so that people can sit down and talk to a judge and ask those necessary questions. Why do you think this? Why do you think that? So I think that the more that I serve out there on these boards that involve children's lives and adults' lives and military lives, I think those are all access to justice issues, and I think it's informative. It's good for a judge not to use legal mumbo-jumbo to cloud people in the courtroom and to explain these not a euphemism, but an acronym. An FTA. You've got 3 FTAs, so I'm going to issue a warrant. Failure to appear. People, you got to know that. So I think it's being in the community. It's not just the job in the courthouse that's important. It's you got to get out there and work with the people.
Great, and I appreciate that because I know we have a soccer coach here. I know we have a gentleman that helps with gun education, shooting things, that kind of stuff. And I really do believe that we do need to be knowing you as people instead of just a judge that we only hear when elections are around.
Right, and I don't just, I don't shoot at stuff, but I'm active with my church. I serve on my kids' school board. I've been active in their schools. Part of it is just number of hours in the day, but I'm very active on their school board in our church. Also, there's a great program through Administrative Office of the Courts called Judges in the Classroom. That's where you can go into all levels of the school system. I was a team teacher for street law, which meant that for an entire semester I was paired up with a social studies teacher in a high school and taught a class with them. So I just did want to clarify that I am out there.
Yeah, no, and I really applaud you all for doing that because it does help us understand who you are. Well, I'm sorry. John doesn't like how I'm holding the mic, but that's fine. So anyway, guys, we're going to say good. We have one more question. Last question.
I'm Jeff Broadhead. Real simple. Case law. I keep hearing little bits and pieces of that bandied around. And we have constitutional-based laws in this country. And case law is law that is legislated from the bench, basically. A decision and that some judge made at some point, and it becomes de facto law. How do we correct those situations when the courts say, oh, well, case law says this, that's the way it is? Is there any...
Well, we're a common law country.
Yes.
And common law is not, as you know, not statutory law. It is the common law. And it should reign supreme. And common law is the legal opinions of the judiciary applying the law like the Constitution. But in the Superior Court of Spokane County, in my opinion, the judges do not legislate, but they do not create case law. They are there and they are obligated to follow the legal opinions of the courts of appeal above them. And so I think your question would probably be best directed to a Court of Appeals candidate or a Supreme Court candidate. But as a trial court judge, we got to obey the precedents.
Well, I want to say thank you to all of you for hanging in there. I mean, I'm no more questions. We're done. We're done. So just really thank you so much for being here, spending your evening. Some of us have eaten, some of us has not. So it's dinner time for a few of us, and just honestly, 5 o'clock in the morning is early. I get that. So appreciate your time being here. We'll see you 2 on the November ballot. We'll see you 3 on the primary ballot. Those were mailed out today in our mailbox. So now you have a good understanding of Randy Brandt, Patrick Johnson, and Lyndon Smithson. Real good. So anyway, thanks again so much for being here.